Hello and welcome back to the Florida Rights Institute educational video series. We're going to do an overview of the right to record police in public places, and so we're going to go over the protections that Floridians have in recording police. A reminder as always that the following presentation is meant for informational purposes only and is not intended as legal advice. You should seek a licensed attorney if you need legal advice for your specific circumstances. The Florida Constitution specifically protects the rights to speech. Under Florida Constitution, Article 1, Section 4, the freedom of speech and the press is enumerated. Every person may speak, write and publish sentiments on all subjects, but shall be responsible for abuse of that right. No law shall be passed to restrain or abridge the liberty of speech or of the press. In all criminal prosecutions and civil actions for defamation, the truth can be given in defense. So as can be seen here, it is clear that the Florida Constitution protects the freedoms of people to be able to speak and to take note of their environment, which is of course fundamental to being able to record so that one may speak about what is going on. In addition, Florida Constitution Article 1, Section 5 protects the freedom of assembly. This is also important as people may want to assemble in order to record police. The U.S. Constitution also protects speech rights. The Bill of Rights in Amendment 1 says specifically that Congress shall not abridge the freedom of speech or of the press. And this right has been held to apply as to the states under the 14th Amendment. The incorporation, which is another way of saying the application of the First Amendment, came through various cases. The freedom of speech, freedom of the press, and the freedom of assembly came through various cases in the early 20th century. The main restriction under Florida law as to making recordings comes under a wiretapping statute. Florida has restricted recording without consent under this wiretapping statute. Under Florida Statute 934.03, interception and disclosure of certain wire, oral, or electronic communications may be prohibited. However, there is an important exception to the wiretapping restriction. Under Florida Statute 934.02 in the definitions section, the definition of oral communication lets us know what types of communications are actually seen as being private and protected under the wiretapping restriction. Here, oral communication means any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. And it does not mean any public oral communication uttered at a public meeting or any electronic communication. That definition is key because it notes that consent is required to record oral communication unless there isn't an expectation of privacy. This is important to be aware of because there are both criminal and civil sanctions that can take place if the wiretapping law is violated. Even though there is a wiretapping law that punishes certain types of behavior, there are still protections on recording based on case law. The right to record police in their official duties has been viewed as an important feature of the freedom of speech and press. The 11th Circuit, a federal court whose rulings can apply in Florida, said that ensuring the public's right to gather information about their officials not only aids in the uncovering of abuses, but also may have a salutary effect on the functioning of government more generally. What this means is that it's an important fundamental right to be able to record officials, including police, so that people can share information about what is going on in government and be able to readily uncover abuses. The Florida Supreme Court has outlined what the expectation of privacy means through a two-part test. The Supreme Court of Florida stated there must be a subjective expectation of privacy and an expectation under the circumstances that society is prepared to recognize as reasonable. What this means is that the person making a communication must not only be expecting privacy, but society must also be viewing it as something that is a reasonable expectation. And lower appellate courts in Florida have generally ruled along these lines in accordance with the test. With these legal protections in mind, the question arises as to where it is safest to record police. Recording police will be at its highest peak of protection when an officer is in public in performance of his or her public duties. It is best to record from places that do not have expectations of privacy from a public standpoint. For example, public sidewalks, public roads, public easements, and public parks. It is important to be careful and to seek legal advice where the expectation of privacy may be present or statutorily announced. It can be easy for someone to accidentally move from one place that is a safe place to record into a place that is not safe to record. One must always be careful about their surroundings and be aware of what kind of property they are stepping on when recording. Thank you for listening to the Florida Rights Institute presentation on recording police. For more informational and educational videos, visit www.floridarights.org.